So you ever wonder what happens when things go wrong? Someone gets hurt from a slip and fall, or maybe a product they bought turns out to be dangerous. How do we as a society figure out who's responsible and how to make things right? Well, that's exactly what we're going to break down today, the tort system. It's the framework our civil justice system uses to deal with all kinds of wrongs and provide remedies for harm.
All right, here's our game plan. We're going to start with the absolute basics. When the world is a tort. From there, we'll look at wrongs that are done on purpose. Then we'll dive into the huge concept of negligence. After that, we'll explore the kind of weird idea of being liable even when it's not your fault. And we'll wrap it all up by looking at how this applies to the products we all buy and use every single day.
Okay, let's get right to it. First things first, let's nail down this word at the very center of our conversation. What exactly is a tort?
At its heart, it's really simple. The word tort just comes from the French word for wrong. But, and this is a huge distinction, we are not talking about criminal law here. Criminal law is about punishing people, with things like jail time. Tort law, it has a totally different goal. Its main purpose is to provide a remedy, which is usually money, to try and make the injured person whole again.
So these disputes all play out in a civil courtroom. You've got your key players. The plaintiff, who's the person that got hurt and is bringing the lawsuit, and the defendant, the person or maybe the company that's being accused of causing that harm. They both come to court to present their side of the story.
And this is where things get really interesting, because the jobs in the courtroom are split. Think of the judge as the legal referee. They decide all the issues of law, like which rules apply or whether a legal duty even existed in the first place. The jury, on the other hand, gets to be the fact finder. Their job is to listen to all the evidence and figure out what actually happened, and if someone was harmed, what the damages should be.
Okay, now that we've got the basics down, let's move into our first major category. We're talking about wrongs that aren't accidents. These are things that are done consciously, on purpose.
So here, the person committing the wrong, we call them the tortfeasor. They know what they're doing is harmful. This covers a whole range of actions. You've got things like defamation, which is all about hurting someone's reputation with lies. And then you have something like assault, which interestingly isn't about actually hitting someone, but intentionally making them fear that they're about to be hurt.
But let's be real. Most of the harm that happens in the world isn't on purpose, right? It's usually the result of someone just not being careful enough. And that brings us to the most common type of tort by far, negligence.
The whole concept of negligence really boils down to one simple but incredibly powerful idea. As people living in a society, we all have a basic duty to act with a certain amount of care so that we don't hurt each other. When we drop the ball on that duty, well, that's negligence.
Now, proving negligence in court isn't as easy as just saying, hey, they were careless. Nope. The plaintiff has to prove all four of these things in order, like checking off boxes. First, that a duty of care existed. Second, that the defendant breached or failed that duty. Third, and this is crucial, that the failure is what caused the injury. And finally, that the injury resulted in actual measurable harm.
And this right here, this gets to the absolute core of what a jury has to decide. The standard isn't about what a superhero or a perfect person would do. The question they have to answer is much more down to earth. What would a reasonably careful, ordinary person have done in that exact same situation?
All right, now we're going to get into a category that's pretty fascinating and honestly a little weird. It's called strict liability, and it's where you can be held legally responsible for harm even if you weren't careless, even if you did everything right.
Okay, take a look at this picture. Let's say the owner of these horses has a state-of-the-art fence, top-of-the-line security, the whole shebang. But a tornado comes through, rips down the fence, the horses get out, and they cause a big accident on the highway. Even though the owner did nothing wrong, they could still be held responsible under strict liability simply because the law sometimes considers keeping large, powerful animals to be an abnormally dangerous activity.
So, how does a court decide what counts as abnormally dangerous? Well, it's not just a gut feeling. They basically go through a checklist of questions. They ask, how high is the risk here? If something does go wrong, how bad could the harm be? And this is the real kicker. Can you eliminate the risk just by being careful? For some things, the answer is just no. The danger is baked right in.
Okay, this next part is huge, and it's an area of tort law that affects literally all of us as consumers. What happens when the things we buy, the products we use every day, end up hurting us?
Well, the rule is pretty broad. If a product has some kind of defect that makes it unreasonably dangerous, pretty much anyone in the chain of getting that product to you could be on the hook. We're talking about the company that designed it, the factory that built it, the distributor that shipped it, and even a store that sold it to you.
So, the problem with the product can come from a few different places. It might be a manufacturing flaw, a 1 in a million mistake on the assembly line, or it could be a design defect, which is much worse, because it means every single one of those products is unsafe by its very design. And finally, the product could be built perfectly, but it just doesn't come with the right instructions or warnings about its hidden dangers.
But wait, the story doesn't end there. It's not always a one-way street where the company is 100% to blame. The law also takes a hard look at the behavior of the person who got hurt.
And wow, this slide shows just how much the legal thinking on this has changed over time. For a long, long time, we had this rule called contributory negligence, and it was brutal. If you were found to be even 1% at fault for your own injury, you got zero, nothing. The modern approach, which most places use now, is comparative negligence. It's way more fair. It just reduces your final award by whatever percentage you were found to be at fault.
And there are other defenses a company can use too. For example, if you use a product in a completely bizarre way it was never designed for, that's called product misuse. Or if you know for a fact that a product is broken and dangerous, but you decide to use it anyway, well, that's called assumption of risk. Either of those can reduce or sometimes even completely wipe out the manufacturer's liability. So, after going through all these different rules and categories, what's the big takeaway? When you strip everything else away, you find one simple, fundamental goal at the very heart of the tort system: compensation. The whole point is to use money to try as best as possible to put the wronged person back in the position they were in before the harm ever occurred.
And that really leaves us with a big, lingering question that the legal system is always wrestling with. As our world gets more and more complex, filled with advanced technology and shared public spaces, the tort system is in a constant search for the right balance. It's a tough question. Where do we draw that line between our own personal responsibility to be careful and the duty of companies to keep us safe from harm?